until the historical picture is built up upon multiple sources and multiple perspectives, until the record has been cross-examined and corroborated many times. Historians never rely on the accounts of others. They examine and re-examine the records. They must always be on the alert for tendentiousness, and especially wary of historical accounts that politicians make use of. If a historical account gives comfort to a politician, then it should probably be rewritten. The instrumental use of history is entirely at odds with the skeptical discipline required of the historian. Fourth, history takes a lot of time. Now, if none of my other points is persuasive, or if the disciplinary difficulties are just experienced as mild discomforts, originalists might at least take that point seriously. If they really believe that judges should be faithful to history, they must genuinely want to get the history right. And to do this requires meticulousness and diligence and patience and years of work. Judges don't have that sort of time. Now, many judges, I won't speak for the United States, but in Australia at any rate, seem to think that history can be done easily and quickly, especially now that many records are available that were not available in the past. So the Australian Constitution was written at conventions in the 1890s, which were open to the public, and there were Hansard reporters there. And the entire Hansard record of the federal conventions, around 6,000 pages of debates, is now digitized and online, and it's now very easy for a judge or the judge's clerk to search for keywords or the names of convention delegates to find out what was said in the course of a debate about particular constitutional provisions. And typically, strangely enough, and I'm sure this never happens in the United States, the justices of the High Court gravitate towards what was said by the notables, in particular the 5 convention delegates who were later appointed as justices of the High Court. Now, doing that is not doing history, any more than looking up a dictionary definition of a term or reading a selected passage of Blackstone is doing history. Speed history is not history. Now, this is not to say that judges can never do extracurricular history. Some, indeed, may have been trained as historians before they entered the legal profession. But even trained that way, they can't spend years researching the history of a particular constitutional provision applied to a real-life dispute. That would be simply incompatible with the legitimate expectations of the parties, not to mention the judicial task. Judges have limited time to reach conclusions. So should the time-poor judge rely on the work already done by the time-rich historian?